This is Banwo and Ighodalo's special legal podcast, with focus on thorny matters and novel issues in the legal and regulatory environment impacting transactions in this jurisdiction. On this podcast, you will listen to Banwo and Ighodalo's legal experts bring to the market on weekly basis fundamental developments and emerging issues in legislation, regulations, judicial decisions, and arbitral proceedings considered to be of interest to the legal market and to domestic and international investors across sectors of the economy.
The speaker on this episode is Chinasa Uwana. She is a senior associate in the firm's intellectual property and technology practice group. Also a versatile IP lawyer with a keen interest in helping startups, creatives, SMEs, MSMEs and other business owners protect and manage their intellectual property rights. Today, she'll be talking on the copyright in gospel music. Can you give us a brief overview of IP rights in music and the licenses required for use of music in different settings?
Yes, thank you. Intellectual property or IP rights are legal rights which result from intellectual activity in the industrial, scientific, literary and artistic fields. IP law aims at safeguarding creators and other producers of intellectual goods and services by granting them certain time-limited rights to control the use made of those productions. So those rights do not apply to the physical object in which the creation may be embodied, but instead to the intellectual creation as such. So when you talk about IP rights in music, I would say this. It is important to know that the music we love and enjoy on our headphones, Instagram stories, radio, at our events, and use in advertisements, etc., are the products of hardworking creatives and the people that invest in their music production. So, the law recognizes the value in music and other creative works and guarantees protection in them through copyright. Copyright is what protects original works of authorship that have been fixed, including literary, dramatic, artistic, and of course musical works, which is the subject of this discourse. It's important to know that in one musical work, there are usually several rights involved. These include copyright in the underlying musical work, that is the composition, the melody, lyrics, and so on, and then copyright in the sound recording, copies, masters, CDs, vinyls, streams, and so on. In addition to this, we also have performance rights, which belong to the performer of the song on the recording. While recognized in the Copyright Act, it's not strictly speaking a form of copyright, but it's a form of neighboring rights, Finally, copyright in the underlying musical work, that's the melody or lyrics, is accompanied by what we call moral rights. Simply put, moral rights are the right to claim authorship for or be credited in the use of the work, or object to the distortion of and to seek relief in connection with any distortion, mutilation, or any modification, or any other derogatory action in relation to your work, where such action will be prejudicial to your honor or reputation. So at its simplest, copyright is the right to copy and control the use of the original works that one creates. This right to control the use of the work is often, licensed or assigned in exchange for compensation. Moral rights, however, belong to the author in perpetuity, So for the use of music works, there are all sorts of licenses you would need to get. Like we said, copyright in a work is the right to do or control the doing of specific acts in respect of that work. Therefore, a license is required to use a work where your use comes under the specific acts identified by the law as requiring authorization. To be exempt from licensing, you have to fall under the exceptions to copyright provided in the second schedule to the Act. So, I'm just going to run through those rights, that you require a license for. Copyright in musical composition, you will need a license to do the following acts in respect of a musical composition: a reproduction in any material form, recording a cover of the song, example where you talk about Sinachi's song Waymaker, public performance, that's playing the song and, for instance, at a church or at an event, the right to produce, reproduce, perform or publish any translation of the work, for instance, translating from one language to another language, the right to make any cinematographic film or recording in respect of the work, example, making a music video, the right to broadcast or communicate the work to the public, by a loudspeaker or other similar device. So for instance, playing the song on NSPBD, make an adaptation of the work, for instance, remixing the song. There's also copyright in the song recording, provided under Section 6 of the Copyright Act, which deals with the direct or indirect reproduction, broadcasting, or communication to the public. Communication to the public includes, in addition to any live performance or delivery, any mode of visual or acoustic presentation, but it doesn't include broadcast or rebroadcast, and then distribution to the public for commercial purposes, copies of the work by way of rental, lease, hire, loan, and so on. And then the last one I would mention is performance rights. Performance rights covers, doing of any of the things I'm going to list now without the permission of the performer. So if you do any such thing without the permission of the performer in writing, it's regarded as infringement. The first one is making a recording of the whole or substantial part of a live performance. So for instance, making a video of Sinach performing her popular Waymaker at a church and posting it on YouTube.
Wow.
Or broadcasting live or including live in a cable program the whole or a substantial part of the live performance. So for instance, if the Elevation Church service should broadcast on Trinity Broadcasting Network, or performing in public the whole or a substantial part of the performance. Example, playing a song in church or in a hotel or at an event. Or in the course of trade, that's in business, selling or letting for hire, offer, distribution, display for sale, and so on. So all of these are the various, ways in which you could be said to infringe or to have infringed on, copyright if you not obtain the necessary license to use the music.
Wow.
Yeah.
Now, for this next question, there's been a lot of deliberation around it, and I really cannot wait for you to shed light, on it and make it clear enough. I really cannot wait. Now, given the message conveyed in gospel music, some actually think it should be free. Should gospel music be produced for commercial purposes at all?
Well, I'm not going to give a straightforward answer to that, because let me talk like a lawyer. It depends.
Exactly.
When Christian musicians like the Elevation Worship or Hillsong drop new songs, it's not uncommon to have other worship teams perform them or play them at church services. The idea is that the songs have been, dropped to bless the congregation and all of that. And while Christian musicians are happy to see their ministrations go far and glorify God, there's also the argument that they're entitled to proper recognition and compensation for the use of their music. As we had talked about before, music, whether it's gospel or contemporary, is a product of hard work and investment, which results to value. Therefore, irrespective of the message being passed across, there should be some reward for that value, and the law recognizes this. That's why we talk about copyright, a bundle of rights which includes economic and moral rights. I believe it's the prerogative of the copyright holder to determine if his rights should be commercialized or not. It's important to note that you risk copyright infringement action, for the following reliefs like accounts of profits or damages, whether special or general, where you do not obtain the proper authorization from the copyright owner. And recent news indicates that Nigerian music creatives are even beginning to assert their rights in music. In 2005, Akande Akimbode Emmanuel released a song called I'll Never Be Ungrateful. This song was later recorded without his consent on an album released by the RCCG National Praise Team.
Wow.
And allegedly without his permission or acknowledgement. And at present, he's suing RCCG for 350 million naira, damages. We have the case of Sir Jude Nam, veteran Catholic music composer, who composed the song Som Tochukwu in 2001, and who is presently suing 5 Star Music and KC for copyright infringement to the tune of 150 million naira regarding their release of their song Cultural Praise, a recording incorporating this Som Tochukwu song, allegedly again without his permission. While this podcast is not a commentary or passing opinion on these cases, it's a great opportunity to visit the position of Nigerian copyright law on the use of music. But suffice it to say that where value has been created, particularly value coming from, intellectual property or IP, there should be some sort of reward. But then again, it's subjective. It depends, on whether the author wants to commercialize it or not. Yeah.
Wow. Awesome. I think that did a great sense of, justice to this question. Okay, what I have here is, what are the compliance challenges producers and users of gospel music face?
I would say the compliance challenges they face would also be like what most music producers face, whether, gospel or not. But obviously this is a special case as well. In the first place, most people don't even know that they need licenses. And I'm talking about generally for any type of music, and then in particular for gospel music, because these songs, you sing them in churches, sing them at events and things like that. And most people just feel, wow, this is a beautiful song. I can use it. I can play it at my wedding. I can, for different purposes. And they don't even realize that they need licenses in the first place. Exactly. That's a major, major challenge. I think that's the most important one, And then the next challenge is the challenge of where to get the license. So even when people know that they need to get a license, the idea is, where do I get it? How do I get this license? And all of that, right? I know there are certain bodies that purport to, assist Christian musicians get their licenses and things like that. And we have things like the CMOs, that's the copyright management organizations and all of that. But the truth of the matter is that it is best to get permission directly from the copyright or the rights holder, whether it's a copyright or neighboring right. So for instance, for Sinach's popular song, Waymaker, which was one of the biggest songs of recent, though originally recorded in 2015, so many other Christian musicians, foreign and local, have reproduced the underlying composition, and they made their own covers between 2019 and 2020, However, to do this, we would imagine that they would have reached out to Sinach directly as individuals, for one-time permission or something like that. I'm not privy to the terms of these specific deals, but where they are done in Nigeria, whether the permission was granted for 1 naira or 1 million naira, they would have to always recognize her moral rights. That is the right of, crediting her as the songwriter or composer of the track, However, it's clear that direct permission may not always be feasible. So for instance, your church, business or event may play music from so many different composers or performers or record labels from several countries. It will not be easy to get a license from every single one of them. And it will also be expensive to negotiate individual licenses for all the songs that you want to play or that you play, And this is where collective management organizations, I mentioned that earlier, CMOs, come into play. Depending on how they are set up, they offer different licenses on behalf of their members who are rights holders. This includes a blanket, performance license, which once obtained permits public performance of music from the catalogs represented by the CMO. Currently, we have the Musical Copyright Society of Nigeria, which has reciprocal agreements with foreign CMOs that enable it to receive royalties from certain uses of their music and all that. We had the COSON, but at present, that's not, really valid. However, it's important to know that MCSN, that's the Musical Copyright Society of Nigeria, does not represent all the artists in the country or abroad. And then the final thing I'll talk about in terms of challenges is enforcement. Because the CMO space in Nigeria has been fraught with controversy, for instance, COSON was suspended in 2018 and eventually lost its license, there's some confusion about the scope of licenses. Even with MCSN, some people have had some, reservations about how they've gone about their business and all that. So there are questions like, do the catalogs cover all the music you would use? If the catalog isn't all-encompassing, why should you get a blanket license from one and risk legal action from an artist not covered by their catalog? Are they permitted to issue mechanical licenses or just performance licensing? There are so many questions and issues with enforcement, so these are some of the challenges. First, people don't even know that they need to get a license.
Exactly.
Secondly, when you even know you have to get a license, the idea is how, where,
exactly.
Who, and then enforcement. Yeah.
Awesome. Fair enough. So before we let you go, Chinasa, what is the way forward regarding the use of gospel music? Any recommendations at all going forward?
I would say that as much as possible, people should endeavor to credit songwriters and composers where their work is used, in recognition of their moral rights. For things like hymns, a lot of those hymns, are already in the public domain, which is to say that copyright has, lapsed and it's now free for everyone to use. But there are certain hymns that are not, that are still, protected by copyright, for instance. And so people should always be careful before you use a song and all that. First of all, credit the songwriter, credit the composer, as far as possible. At least let them have that moral recognition, the moral right recognition, right of attribution and all of that, Disclaiming copyright ownership is not the same as recognizing authorship, okay? And then there should be deliberate steps to look into, performance licenses. Don't just take it for granted that, I can't get this license, so I'm not even going to try. Where there's a will, there's a way. So in many circumstances, if you actually look to get, these licenses, particularly for those that are being used, in public, in churches, and, in big events and all of that. And then do not undertake specific projects. Example, making a cover of a gospel song and releasing on Spotify or Apple Music or something like that, or using it in advertisements without getting the rights holder permission. You will just be opening yourself up to, an action in infringement. And like we said, there could be demands for damages, special or general, or accounts for profits and things like that.
Knowledge has been served. Thank you for listening to this episode of Banwo and Ighodalo's Legal Podcast. For more insights, hit us up across any of our socials, that is on Instagram or Twitter, at Banwo and Ighodalo, or at Africa Business Radio.